Good evening, everybody. I'm so glad here we are at our fifth training meeting for the Jural Assembly, and we are doing a sort of mock trial today. I just want to be real honest with you. I don't have time to prepare a mock trial. We're in the middle of preparing the most probably monumental case in American history right now. It has come to me earlier today or this week from Nina and them who have talked to others across the country and through the coordinators there. Our court case is the first one that has done a full grand jury and has gone all the way to the process, and no one else has taken it to court. So this will be our first case of taking it to a court, doing ex parte Milligan, and taking ex parte Milligan all the way to the Arkansas Supreme Court Justice, and having them look at our decided case. Once the case is decided, then they will look at it and they should pass our verdict down to the circuit court. That is the way it is stated in ex parte Milligan, which most of you know. We have gone through that whole process of doing everything correctly to do ex parte Milligan, to get that information out to all of the government officials' hands in the state as well as the important ones in the country. So I just want to let all of you know how proud I am of you, that we are pushing forward and continuing to push forward. I also want to let you know that I don't want you to be scared. Even though none of this stuff has been done before in 160 years, it hasn't been done, and it is putting things back where they are supposed to go. When I want us to be reminded that when these courts would come together back then, they would come together, they would hold their court and make their decisions. There's not a lot that's planned out in advance when it comes to the jury, and as far as the court is concerned, there's just simple procedures that have to be followed in order for everyone to play their part and for it to go lawfully, correctly, and done well. The most important part of that is going to be the court of record, which we mentioned last week. That court of record is the whole case from the plaintiff or the claimant that will actually move forward to the Supreme Court for Arkansas. So that piece of our case will actually go. What's actually recorded in the verdict and those things just stay here recorded for our records. So the paper documents are actually what's going to go. So when you look at what we have tonight, what we're going to do, let me see, how many do we have on the call? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So we have enough people on the call tonight to actually fill some of these roles. We won't have enough for a whole jury to go, but we can actually have some of you actually roll out as if you're in a jury room. So I'm going to so we have Daryl Penner here tonight. We have Nina. We have Robin. Cheryl, I'm putting you as the claimant. It's going to say like Julie Little or something on there. I just didn't want to use anybody's real names and stuff on this mock trial. So Cheryl, I'll use you there. Robin, you'll be in your spot. Daryl will be in yours. May have to have someone take some different spots as we go here. Let me share my screen and we'll see what we've got. So on this outline, when we come into our court session on Sunday, so when we come into court on Sunday, everyone will have a copy of this that we have right here. Everybody's going to have a copy of this that's supposed to be in court. Adam, he's not here right now, but Adam LaSalle is going to confirm the evidence. He's going to make sure that only the people that are supposed to be there are in the room. So it's going to be our 14-man jury, which is 12-man jury with 2 alternates. In case something happens, we will keep a total of 12. for any reason if someone has to leave. So we need our 14-man jury, and our officials. Then we'll have Adam will also have a list if any defendants will be coming at that point. At this point, there have been no defendants that have said they're coming, or state officials. So, but we'll know that as we come to the end of the week. So Adam would make sure that only the people that are there, he is going to have a list of who all is supposed to be on that call and who all is not. So he can be looking at that, making sure there's no outsiders. As far as him having to line out a process for arbitration, all of the information and evidence that goes to the jury will actually be given to them. They will have it in their possession, as well as the jury resolution statement, which is right here. Let me show you guys. There's a jury resolution statement that's here. That'll be the final thing that's filled out. And then they'll also have in the jury, they will have a copy of the jury deliberates over the charges. So malfeasance, dereliction of duty. So the charges in this case, this mock case today is malfeasance, dereliction of duty, theft and unlawful conversion, crime of personage, tort, and malicious prosecution, okay? And then the jury will also have a copy of what was stated from the grand jury, okay, for John Doe and Jane Doe, what was said from the grand jury of what their charges should be and why they're there. So the jury is going to decide whether they are guilty, not guilty of these, and then if so, what are the damages? All right, so that's going to be with the jury packet, along with all the evidence, the court of record, and the law of the case. All right, so on our court procedure, we're going to have Will Harrison as the justice tonight to read through this, and we're going to have Nina. She'll do her part, and we'll scroll and just do these pieces. Robin Green, Daryl Penner, each one will read through these pieces. Cheryl, I'm actually going to have you be the witness. I'm going to have you be Julie Little. And then I'm actually going to be the claimant tonight, because that way I can tell what happened to me and I can give a little bit so the jury can go. Is there anyone that wants to cover spots that aren't listed? I've got Nina listed, Robin, Daryl. I think that's about it. Will the rest of you be jury members, or is there someone that wants to be a defendant? Anybody? No? Let me go back here. So, is everybody ready to roll through one of them? Are y'all ready to roll through one of these? Being in said positions? I need a defendant, though.
Can y'all hear me?
Yes.
Yes.
You can?
Yes.
You can hear me?
Yeah, who are you?
Keely.
Keely, I'm glad you're here, Keely. We hear you just fine.
Yes. Well, I keep quiet because I didn't really think that you could hear me, because I just did the dial-in.
Well, you can mute you're not muted, so yes, we can hear you. And if you want to mute, I don't know how you do it on the dial-in.
Yeah, no, I'll just be quiet.
Okay.
I'll just.
So
we're going to. If you need me to be the defendant, I can do whatever.
Absolutely. How about you be my defendant, Keely? Will you be my defendant today? You're going to be John Doe.
Yeah.
Okay, John Doe. And we're just going to kind of make this up, so when we get up there and when you defend yourself, you're just going to defend off of what I've said, okay? Kind of what.
Okay.
You're going to be a judge, and and you've treated me wrong, okay?
I'm the defendant. I'm the judge that treated you wrong?
That's it. You're going to be you're going to be John Doe, the judge that treated me wrong. I'm going to be Julie, okay? And Cheryl's going to be the witness, and then I think I have all my officers that actually speak. So you guys that speak as officers, y'all just unmute, okay, when it's time for you to speak, and I'm going to share my screen, and we'll see what it says, all right? Let me go back to where my screen is.
Okay, and now I don't have a screen.
That's okay, because basically you're just going to, we'll show, you won't have to have a screen, because you'll just speak. You're just going to speak.
Okay.
Now, remember, when we do this, everybody's actually going to have this ready and printed out for the case on Sunday, and it'll have everybody's names in it. It'll have everything done correctly. Everything will be done and completely finished, but today we're just going to kind of run through it. So let's pretend that Adam has already made sure everything's good, and Will, our justice, is going to verify everybody's here. So he's going to verify, which we just verified, everybody's here, and then he's going to start. And he'll push the record button. So we've already done that.
Yeah. All right. So today is Tuesday, January 16th, 2024. The time is 6:42 Central Standard Time. This is the Arkansas State Common Law Court. I'm your State Justice, Will Harrison. I'm going to have each one of you affirm this by saying I affirm after I read the affirmation. I will faithfully perform my duties as an officer of this common law court according to the principles of natural justice, due process, and the common law. I will act at all times with integrity, honesty, honor, and lawfulness. I recognize that if I fail to consistently abide by this affirmation, I can and will be removed from my office or as a juror. I make this public affirmation freely, without coercion or ulterior motive, and without any mental reservation. So when I call your name, please answer, I affirm, if you agree to this affirmation. We have our marshal, Adam LaSalle.
I affirm.
Court recorder, Nina Williams.
I affirm.
Court clerk, Robin Green.
I affirm.
All right, my bondsman, Daryl Penner.
I affirm.
My notary, Kimberly Baker.
I affirm.
And as far as our jury members, we would do the same in that case for all 12 or 14.
Right. They would just we'll have a list of all the jurors at that time, and we're going to have their names put in. So we'll just read off, Roger Lane, he'll affirm. So all your jurors, I didn't put them in there because I didn't know who was going to be on the call tonight to put them in. But so, for instance, will say, do a couple of them.
Roger Lane, our foreman. Mark Newman. Can you hear me? There you go. We can't hear you, Mark, but we see that you're off mute.
How about now?
There you go.
Yep.
All right, Michael Osborne.
Can you hear me?
Yes.
Okay. Yes, I affirm.
Very good.
All right, and we'll do one more. Donald Ewing.
I affirm.
Very good. And then we would go through all 12. We're not going to go through all 12 because we don't have all the jury here, but basically everyone sees how that flows, and they'll all be listed right there, so we won't actually have to switch pages to go through them.
So now we can hear from our recorder.
This is number AR 026-2023-001, and the living woman's name is Jackie Little. The accused is John Doe and Jane Doe. Oh, this is case number AR 026-2023-001, and the living names of the claimant is Jackie Little. The accused are John Doe and Jane Doe.
Call to the order for the case. Claimant Jackie Little is first to testify.
Yeah, Jackie Little. Excuse me. Do you, Jackie Little, promise to tell the truth?
I do.
Do you, Jackie Little, agree to abide by the jury's decision?
I do. Okay, so what will happen now, and I know it says Cheryl, I'm sorry. I was trying to change all of this to where, because I had it all in here where it was for the actual case and not for a mock. Okay, so now, Jackie Little, here I am, and I'm going to come testify. And when I come testify, I'm going to pull up my evidence that I have, which is not up for some reason, but that's okay. I can pull it up real quick.
I'm just trying to see if anybody can hear me. Can you hear me?
Yes, we hear you.
Oh, cool. I thought that my microphone didn't work on this computer. Okay, cool. Great. Thanks.
All right, so what's going to come up next is the court of record. And so I'm Jackie Little, and I'm going to come in, and I'm going to start my case. And the venue of this case, all evidence described here or thereto are occurred on the unincorporated land of the county known as Garland County in the Republic named or known as Arkansas State. And therefore, all actions herein shall proceed by necessity according to the course of the common law in a court of record in said county. The law of this case is hereby decreed the law of the suit. Attachment A is incorporated by reference as though fully stated herein and applies to all causes of actions and declarations at law in this court of record at all times. At no point or time shall these actions in this court of record be subject to the following for any reason: principles of equity, maritime, admiralty, ecclesiastical, or military jurisdiction, practice, rules, appeals, or decisions, save what the lawful tribunal of this court of record shall deem appropriate as stated in the law of the suit of this case, of the law of the suit. Comes now Cheryl Jean, House of Corvell, who at all times mentioned in the following declarations is at law in Arkansas. Now, I'm not going to read all the way through this tonight. I'm just going to tell you guys, look, here's what happened. I have had 4 court cases, and they have taken my car, and they have taken my animals, and I didn't know what to do. And so on August 1st, I challenged jurisdiction, and so down here is going to be all of my paperwork where I've challenged jurisdiction, and I gave them 30-day notice that I challenged jurisdiction, and they didn't respond, and I sent a second notice, they didn't respond, third notice, they didn't respond, and even after I did all that, they came after me with warrants, and even though they've had warrants, I have had to go into hiding, and I'm owed a court case. I'm owed in the Constitution, in the Arkansas Constitution in 1836. I'm actually owed in Section 2 of that Constitution. I am owed the right to a free trial. I'm right to a trial by jury of my peers. I'm also owed my life and my liberty. That all free men, when they form a social compact, are equal and have certain inherent and indefeasible rights, among those which are enjoying and defending life and liberty, of acquiring and possessing and protecting property and reputation, and the pursuing of their own happiness. That all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of these ends, they have at all times an unqualified right to alter or reform or abolish their own government in such manner as they may seem proper. I am owed the right of a trial by jury, and it shall remain inviolate. That all people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures, and that general warrants whereby an officer may be commanded to search suspected places without evidence of the fact committed, or to seize any person or persons not named whose offenses are not particularly described, are supported by evidence, and are dangerous to liberty, and shall not be granted. So I've had unusual searches and seizures. They've come to my house twice. Once while I was giving testimony at a grand jury, they came to my house and searched my house without a warrant. And so I've had that. Also, no free man shall be taken or imprisoned. This is still part of the Arkansas Constitution of 1836, and that these are my rights in the Constitution, that no free man shall be taken or imprisoned or disseized of his freehold liberties or privileges, or outlawed or exiled, or in any manner destroyed or deprived of his life, his liberty, or his property, but by the judgment of his peers or the law of the land. Well, the law of the land is the common law, and a judgment of his peers is of the common law court with sovereigns of that court. And so I was taken, my animals were taken, my property was taken, I can't go home. All of those things have been taken from me, and I haven't had a case of my peers until today. Another part of that is that no person shall be charged for the same, no person shall for the same offense be twice put in jeopardy of life or limb. Well, on my cases, one of my cases, I was actually arrested twice on the same thing. I was actually arrested once over my animals, and then when they moved it from district court all the way to circuit court, they arrested me again and made me pay bond on the same thing. It was the same case. They just moved it from the district court to the circuit court. And so there again, they've put me in jeopardy twice, and I've had to pay bond twice. That all penalties, this is still part of the Constitution, that all penalties shall be reasonable and proportioned to the nature of the offense. Well, my animals were taken away from me, and there was no due process there. They should have waited. In my mind, they should, if they had a problem with my animals not being fed, they should have actually just come and checked on them for a couple of weeks or a few weeks to see that they're actually doing better, because it takes animals quite some time to be able to show that they're not starving anymore when they come in for a rescue. And so I should have gotten that due process instead of all my animals just being taken with no chance to rebut at all. Another part of that is that no man shall be put to answer any criminal charges except by presentment, an indictment, or an impeachment. Well, that part of the Arkansas Constitution states that I shouldn't have to answer any criminal charge without a presentment or an indictment. Well, those come from a grand jury, and so they didn't have a grand jury meet with an indictment. They just came to my house and took my animals and just took me off to jail. And so I see lots of things in here that the laws have been broken against me. And this part says that the enumeration of rights shall not be construed to deny or disparage others retained by the people, and to guard against any encroachments on the rights herein retained, or any transgression of any other higher powers herein delegated. We declare that everything in this article is accepted out of the general powers of the government, and shall forever remain inviolate, and that all laws contrary to these or to the other provisions herein contained shall be void. So the laws that these cops and judges were using to come after me, it goes completely against what the Arkansas Constitution says, and I feel violated, and I feel like they have stolen my property from me and have just taken me through the ringer, and I don't know what else to do, but I need restitution. They've probably $10,000 worth of fines and fees, and I've had probably about let's see, when you count all my animals that were taken from me, you're looking at probably $15,000 worth of my animals that were stolen from me and sold that I can never get back. And anyway, so I'm coming to get restitution. And none of these, when I gave all of these notices for jurisdiction, because we now have the Arkansas Common Law Court set up. I gave notice to them on that was the court that I needed to go, and I claimed I invoked Ex parte Milligan, which says that I can't be charged in a military tribunal if I'm a civilian, and that if a court is set up, I have to go to that court, but they wouldn't relinquish me to that court to be for a jury of my peers, and so. I'm coming to this court now today to lay out all of the stuff that they've maliciously prosecuted me, and here's all the receipts of all the monies that they have against me, and I want restitution. I haven't been able to work for 6 months or be able to live in my house. I've been in hiding, and so I've brought all this before you guys on paper to tell you how much I've been taken from, and so basically I'm laying it at your feet. And I'm just going to leave it at that, guys, for the testimony of what has gone down with Julie Little. Oh, where am I at? I got to go to a witness.
Okay, do we have any jurors that would like to ask any questions at this time?
I'm Jackie Little, and I just finished my statement. So now I'm going to get up and walk off the stand. And when I walk off the stand, we have Julie Little here. That's going to be Cheryl today. Cheryl's going to be a witness. Okay, so when this happens, Will, here's what you're going to do. So as the justice, understand. So guys, here's what happens. Anytime we're in a case, I just want y'all to know, anytime we're in a case, the good news is that if something gets stuck, our justice is the one that will always pull things back on track. So what the justice will say is right here. Yep.
All right, so Robin Green. You want to call to order our other witness?
Call to order for the case, the witness. Julie Little. Right? Yep. Or who is it?
Yes.
Julie Little.
Okay, bondsman, do you want to affirm Julie Little?
Yes. Do you, Julia Little, promise to tell the truth?
Yes.
Do you, Julie Little, agree to abide by the jury's decision?
Yes. So I was at my mom's house, and me and my brother and my sister were all there, and we were trying to get some things and go back to our dad's house, and all of a sudden the police came, and they just started yelling and screaming at us, and as they started screaming at us, they said they were going to take us to jail for trespassing, and then they were looking for my mom, and she's not here. And anyway, we were finally able to leave. But over the next month, of time, they would stop us as we were going to the store or as we were leaving school. Every time it seemed we turned around, the cops would be stopping us and harassing us and asking us where my mom was and trying to find her. And it was really scary. And I don't really understand why the cops keep coming after my mom like that. She's never hurt anybody, and she's never harmed anybody or hurt anybody, and has never taken anything from anybody. So I don't understand why I can't just be with her. And so, but the cops I have in my written statement that you guys have, all my written statement, the dates that the cops all came at us and the different things that they did, and I've put that in written testimonies. So that it can be added to the case. Okay, that's all I have. That's all I have.
Okay. That concludes Julie's testimony. Jurors, do you have any questions that you'd like to ask at this time? Okay, if not, my clerk, are you available?
Yes. Call to the order for the case. I can't see the screen.
Oh, is that better? It'll say accused John Doe is third to testify.
Yes. Call to order the case. Accused John Doe is third to testify.
Do you, John Doe, promise to tell the truth?
Yes.
Do you, John Doe, agree to abide by the jury's decision?
Yes. Now, will this judge really say yes? I mean, will he really be there at the trial Sunday?
At this moment on Sunday, none of the defendants have responded to come, and neither have the governor, the Secretary of State, the Attorney General, the Western District, or neither the Chief Justice of the Arkansas Supreme Court. We have invited all of them to come, and none of them have reached out to come. So, at this moment.
Okay.
So, but at this moment, our accused, I don't think they'll show up, but if they do, they would testify. And right. So, in that manner, I mean, basically, they're going to have to say they didn't break the Constitution. I mean, we've laid it out to where they've totally broken the Arkansas Constitution, not to mention the other Constitution. You lay it out. So they're accused of, they're going to have to bring a case of saying they didn't do that, which is going to be difficult. So I would assume they're not going to show up. So basically, that's what Keeley needs to defend right now. At this point, there's been notices sent and no response. So I don't know if Keeley wants to jump in there and try to give herself some defense, but if she wants to jump in there, this is her turn.
Well, that's what I mean. There is none. That's what I'm dumbfounded. I mean, how could they speak other than? I mean, obviously, I haven't done any research on this, but I mean, I'm sure they could come back with statutes and codes and all that, which is not going to apply.
That's it. It won't apply here, and it's even stated in the beginning. It's not on a common law court. So that what they should have done is they should have, when Ex parte Milligan was invoked, they should have let it go. But because of immunity that they think they have, and we don't have common law courts in session, then they think that nothing's going to happen. But now that the common law courts are coming up, then guess what? Our people need to be taken to our courts. So this is the first case of the country right here.
I love it.
So basically, Keeley can't respond. So, I mean, Keeley can say I mean, I don't know. Whatever you want to say there. If not, we'll just keep moving forward. But at this moment, I don't think the defendants will come.
Okay. No, I'm good.
Okay.
Okay. Do we have any kind of inquiry into or as to the evidence and the facts presented here this evening? If the jurors have any questions, now would be a good time to raise your hands, and we can call on you one by one, and we can have your questions answered. And John Doe, you're free to step down from the witness stand. Of course, in this case, we're not in a courtroom. And at this point, we will go ahead and pause the recording. Now the jury's going to gather in the living court in the jury room.
So I guess the first thing is are there any questions that would, because this is going to be the time. So this time right here is if the jury, as you've listened to everything, you jot your notes down, because if you have a question for the claimant, this is going to be your opportunity to get any questions answered that you don't know. Maybe you didn't hear something correctly, or maybe you're confused on something. So if there's any questions, this will go until all jurors feel completely comfortable to go off before you go off to deliberate, because this is all the facts that are ever going to get presented are presented right here. Now, you will have the paperwork with you, but anything you want said can be asked. So is there any questions?
I have one.
Yes.
As the jurors, when would we be presented with the paperwork so that we can be totally familiar with the case?
Mm-hmm.
You should be getting the paperwork just before the case. I'm hoping I can get it out to you a little bit sooner than that. The problem is it's a lot of paperwork to finish, and we just learned how to do it. Usually you would get it well in advance, but I can't get it to you well
my question was.
We're still learning and then putting it all together.
Mm-hmm.
So, for instance, for the case that we have right now, the law of this case is completely finished. I can go ahead and send that to all of the jurors and have that so that can be read over. The evidence of the case is all put together, but it's not put into a PDF just yet. It's got to be all put into one PDF with all of the exhibits, but they all are there. It's just now getting them from all in a long packet and put into one PDF, and they're numbered through exhibits like 1 through 85 or something like that. There's a lot of exhibits, and so those will be numbered out in a PDF. And then the third one is the court of record. And at this moment on the court of record, which you guys just saw, there's big chunks of that have been done. This right here is it. Big chunks of this have already been done. Big old chunks of this have been done. But when you come into the facts have not been put in here yet, and we are still working on the restitution. So that has to be, we're trying to get all of that finished now. It's a lot, and it takes time.
Right.
Mm.
Sure.
So that's kind of where we're at on that. Where was I? Over here.
Okay, so Daryl, do you want to, we'll continue, do you want to go ahead and read off what happens once you go to the, with the jury to the jury room?
Okay, you just want me to read what it says after bondsman?
Yeah, we all need to get a familiarity with where, what we're doing here, so.
Sure, okay. Goes with jury to jury room. Jury will need to immediately vote on jury foreman. Foreman and marshal exchange phone numbers in case of a problem. Bondsman makes sure screen share works and all evidence is able to be seen and used by jury. Bondsman is jury's only point of contact. Once bondsman leaves room, jury begins deliberation.
So basically during that time, our 12-man or 14-man jury, because we'll have 2 alternates that will go off into their jury deliberation room. They will immediately figure out who their foreman's going to be, and that way the bondsman will know who the foreman is, and the foreman and bondsman can exchange numbers and also give Adam Lascelles' number as marshal in case there is a problem. The bondsman is their contact, but if there is a security breach, or the bondsman, which is Daryl, is their contact, but if there's a security breach or some sort of, I don't know, if someone gets in there or something happens, then the marshal is the one that takes care of security issues, and the bondsman is the one that takes care of any other issue that the jury may need. Does that make sense? All right. And then this is where our jury goes in to deliberate, and the jury will have their packet, and they'll also have here, the jury will have a jury decision for their final decision for the clerk and the justice to sign. They will also have in their possession a list of charges, because they'll have, I can send out the list of charges on that stuff. That can go out with the law of the case, because we have the list of charges already done out. That was done out from our grand jury. So this whole case is all being done from the grand jury. So it's coming, everything we've done so far in our doing is all coming from the grand jury through our petit jury. So this actually comes from the grand jury. So then when the jury comes back, so the jury, they'll go discuss everything, figure out what restitution, if restitution needs to be made, then they'll come out to present their findings and return to court. So everybody gets gathered back to the courtroom, and go ahead.
Yeah, so once they're in the courtroom, I'll just state something really simple. Okay, the Arkansas State Common Law Court is now resumed. Has the jury reached a verdict? And then we got different answers here. I guess we could have different answers, but this one here is the jury foreman comes back with no, we have not. And then I myself could have continuing questions into verification of the jury's decision, whether or not it was a hung jury. The final decision is made and spoken to the living court, or if there could be a probability to take it back into arbitration. And then, of course, this would have to do with the, what kind of monetary awards. There's different forms as well to fill out if there was a jury nullification, and any and all the above. And if we needed to reconvene, we could schedule time. And basically, once we schedule the time, the Arkansas Common Law Court is adjourned, and we'll reconvene on Monday, blah, 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 at whatever time. And if we have reached a verdict, of course, the jury foreman will say, yes, we have. I'll say, please read the verdict. And then the jury foreman reads the verdict, and I say the Arkansas State Common Law Court is now adjourned. And then, of course, we'll stop recording at that point.
Right, and that's when, if the verdict did come out, then that's when everything gets moving to start filling out forms and getting all the forms and everything to be sent off to the Supreme Court. So My question to you guys are, do any of you feel like you need to go into a jury at this point and deliberate over me and John Doe, or do you feel comfortable that when it comes time to the jury going in to deliberate that you guys are good?
Yeah, I mean, does anybody have any ideas, perhaps, real good questions that, you could lay out before the jury? I mean, this is definitely a collaborative environment, amongst the 12. So we want to make sure everybody's giving input, and if something doesn't seem right or off to you, you can communicate clearly to one another, and that nothing's withheld. I mean, because these are people's lives, that we're dealing with. Does anybody have anything maybe that they can contribute here as far as, being in that room and maybe helping the flow of things and the communicative level?
Are we going to have a copy or an estimate or whatever of her damages?
Yes.
Yes.
Okay, so that's what we're still trying to figure out too, is like so we're listing everything that they've done to her. We have it listed. We have the monies that they've done, but the restitution, we're basically going to be asking the jury to decide restitution. You will have a dollar amount of actions that were taken. You know what I mean? You'll have a dollar amount. Like you'll have a dollar amount for the horses is about $3,000 to $5,000 a horse. The dollar amount, you'll have those, but then, like in some cases, they'll go double if there were in punitive damages. You can double those amounts or come up with your own amount for restitution. But Cheryl's just going to put everything down, and then that's going to be the jury to decide that. So that way it's done fair and it's not hers. Does that make sense? It's not her making that decision.
Yes.
And I have a question if I was a juror, but would you rather me ask you later, Kimberly?
No, go right ahead, because the court case is going to be up this week. It may be something we need for it.
Well, it's because I don't know this case, but tell me, was she accused or did they just straight go in, no warning, nothing?
Yes. Yes. Straight go in, no warning, nothing. Yes.
Okay. All right. Yeah. And were the animals mistreated?
No.
Okay.
They were part of a rescue business that she had an agreement with people who she owned the land and she had her own horses there, but the rescue was owned by some of her friends, so they had the horses there. They were leasing part of the land for their horses to be there, and they had just come in, so they were very starving, but it takes time for them to not. But anyway, the whole point of it is she should have never been arrested in the first place. Yes, it is her property, but that business was owned by other people, and they took her horses and their horses and took her to jail when that rescue was not even owned by her.
Wow. Okay. That's what I needed to know.
So, any other questions?
Yeah, this is Robin. I have a question that's not about the jury deliberation. So you sent a notice to like the governor and different people. Can the general public, did we send out a notice so the general public could also witness this?
We did not, but what we can do, and this, because now this is something that I know Will and I have talked about. I don't know if Nina and I have, but I know Will and I have. We have our website that we have, the Arkansas Assembly website, which is where our ex parte Milligan and stuff is. It is possible for us to take these cases, like the recorded case of this. If we want to, we can put the recorded case that's up there, and it can be open to the public. It's difficult to open it to the public as far as putting them on our platform, because I don't think I can hold that many people on the actual platform. But it can be streamed. Like, we can stream this to YouTube. We can stream this. We can stream this or save it. So, I mean, it can go out to the public. It's just not this one time, but it can be after our case is done. It can be posted publicly for the public to actually go watch it on our website. And our website does have the capability for that. I did ask. Oh my gosh, my mind just went blank. Penny. No.
Penny.
Yes, Penny. Yes,
I think that it may be okay. Yeah, I think it would be great to have it as a, for Arkansans to see what is actually going on, so that they feel like, we're here to serve everyone, and we welcome everyone. So that's why I was asking.
Absolutely, and if our platform could hold it to go public, we could, but we absolutely in the future can stream these on YouTube if we need to make it a public case. We could stream it while it was going on and let it stream into YouTube or Facebook. We could we have the ability on this platform to stream it, and we also have the ability on this platform to post it on our website as well, which is good. So basically, go ahead, Daryl.
Okay, I just had a question about my position. So I am the only point of contact between, like, let's say, what is this? Can you just amplify this a bit? What would be a scenario, like, would the jury have a question, and it has to go through me, and then I talk to whoever? Or
that's correct.
Amplify.
That's correct. You are the point of contact. So let's just say, if it's, for our instance, it could be that they have a paperwork question of, I don't know where. So the jury, when they come down, there's going to be 4 counts that come down. They're going to have to see if they're guilty or innocent. And so if they're not sure on a law, or if they are not sure on what's in front of them, they can come to ask you a question, and then that question can get brought to Will, and then you can take it back. Another instance where this is an issue is if someone had to leave the room. If at any point on that call go below 12 people in the room, because there's 14, we're going to have 2 alternates. So if we go below 12 people in the room, let's say they have to step out for a minute or walk away or something, somebody's at their door or something happens. If that happens and 2 people drop off and we go below 12, then they'll actually have to stop what they're doing for a minute and may have to take a recess. And if they recess, if we were in a court setting and we were at a building, Daryl, you would be taking them to the bathroom if they needed to go to the bathroom, and just walk with them, because at the time, if they're in deliberation, no one can actually talk to them while they're in deliberation. You would be their point of contact if they needed to order lunch to eat in. It's a little different when we're on the Zoom call. It's going to be way less difficult, and it's going to be way more streamlined, because normally they're not going to need to come out, because on the Zoom call, you can step to the bathroom real quick, or you could, and still hear. So, yes, but you are their point of contact. Yes, and if it's a safety issue, it's going to be Adam. It's going to be like if they feel threatened, or if it's a safety issue or a security issue, it's going to be Adam, but he'll be reached through you. If it's a question on, a law or something like that, it would come out to Will. But Yeah, you're their point of contact.
Yeah, sure, okay. Yeah, I just wanted to, have that clear in my mind that I had the picture.
It's just a little bit different because we're doing it in a Zoom call, but in a normal aspect, you would be the one that's making sure that nobody speaks to them while they're in deliberation. Nobody gets to them while they're there. You take care of all their needs, and if you need help, then Adam is your helper. The two of you y'all are backup for each other with the jury.
Right. Yeah, I understand that. Okay.
Can I ask a question?
Yes.
Oh, can we go all the way back to where she gave us her testimony? Now, let me know if I'm off base a little bit. Do I remember her saying that business would belong to her husband or ex-husband or something like that?
Yes, it was the ex-husband's friends. It was her ex-husband's friends, and she had a contract with them. Yes, the contract was to have the horse. They were going to take care of the horses on her land. But her horses were there too, but they were literally just like renting the land to put the horses on.
Did those people get any kind of charges?
No.
Why are they targeting only her?
That's that's the whole point. All of this. Who gets arrested for trying to sell for not having a title on their house during COVID? I mean, there's some major thing. This case is a monumental case.
Also, I haven't forgotten about the little place next door where that rehab place, whatever. What's going on with that right now? Do we know?
Well, yeah, we have a lot on that. It's actually going to be added to her case. They have actually, anytime that anyone has come to her residence, they've called or come to her house, they've called the cops out there on them, whether it's the kids or whatever. Yeah, they and they won't stop getting on her property. She's got cams up, and they won't. All of these people in this drug rehab won't stay off her property.
Is there anything we can do about that?
Well, she can't call the cops because the cops are working with Sozos, the rehab company, and we have proof of that too. It's just it's crazy. It's all a big thing.
Yeah, we can't. No way she can file like some type of paperwork against them or something.
Well, that's what she's got. Well, she's done her due process on that. That'll probably come through our court. They're right on behind us as far as notices, and they'll be coming to court soon for their trespassing and all of the stuff that they've done too.
That just answered my question. Thank you.
Mhm. So as far as this case is concerned, yes, on the court of record that you guys as jury members. This court of record that you're going to get is going to tell the whole case, the whole thing. It's all going to be in there so it can be easily read and understand. So, yes, Cheryl giving her open testimony on court, that'll be great. She'll give an open testimony, but basically everything is going to be in that packet because that way any judge, any official, any attorney general, any of them can read through that packet and know exactly what has gone down. So that is actually more pertinent, I guess you'd say, than her voice testimony is going to be on Sunday. Does that make sense? It's going to be more comprehensive because she's only going to hit the high notes on the court case because you guys are going to have it all in writing. Which is kind of like what I did. I just hit some high points that were on there, but her main thing that she's going to concentrate on is how they have broken her constitutional rights. Y'all saw all those constitutional rights that they broke, but she's going to focus on that. As far as everything that's happened with all those other cases, you guys have heard all that before, but it's actually going to be listed in there with the evidence so you can actually just scroll through it and look through it yourselves. So, yes, it's coming, and I'm hoping Cheryl, I hope we get it finished as quickly as possible to get it to them. So,
something to your email.
Okay. So anyway, any other questions on that? Does everybody feel comfortable with this format? It's real simple. If we get messed up, y'all don't panic. If we mess up or we just get out, we'll just have Will get everybody back on track. And if he needs to say something, he can. But is everybody comfortable with the format that we have going here?
Yeah, I'll try to give all of you, if we're where you should be speaking, I'll give you some kind of verbal cue, call your name, or ask, where we're at in the process. So I'll try to do my best to keep everybody on cue and myself.
And remember, the most important people here when any time a court is put into session, the most important people here are going to be your claimant, because your claimant is a sovereign. Your defendants are not always sovereigns. Your claimant is a sovereign. Now, of course, all of the court officials are sovereigns, but in that moment, all of your court officials are not in a sovereign role. They're in a citizen role. They're doing a work. So your plaintiff and then your jury. The jury is the most important people. They are what's called our tribunal. They make all decisions for anything that happens in the court in this case.
And one thing I wanted to mention to Keely and to all of us, as a matter of fact, just remember this, that the action that's being brought, the burden of proof lies on the claimant, always. Mm-hmm. Okay? Now, of course, you're going to have your defendants, but the real burden of proof lies on that claimant that is bringing the action against the accused. So always remember that.
And so all of hers will be coming in with proof on that. Now, let me come back to the huddle team. Come back to you guys. We've gone for an hour. Does everyone feel comfortable with the process that we have for doing this? It is, again, the first time it's been done in a common law court being set up by the state in 160 years. If we make mistakes, it's okay, because the main point is to get the information to the jury. That's the key. The key is we have to get all of this information to the jury. They're the most important part of all of it. Does everybody feel okay with this?
I have a good feeling about it. I like what Will said, that, you would try to keep us on point and try to keep the flow there. I think we can do it. We might stumble a little bit here or there, but like you say, we focus on the main objectives, and we can pull that off, I believe.
Absolutely.
Yeah, as long as we get the big item, the big ticket things right.
This is David Williams.
Yes.
In your preparation and your presentation, the common law, as it was at the time of Milligan.
Yes.
How do you plan to address their attempts to come in with statutes that are present day, that's trying to make it apply to this case, and how will you present the real law back at them to defeat their attempt to introduce law that is non-applicable?
Well, that's the interesting thing, because like you said, this hasn't been done in so long with the common law. But basically, anytime you pull up a court of record, which is what this is, our court is a court of record. So the moment we make it a court of record, I read it right at the beginning of Cheryl's thing, that it because common law, here it is. It's mentioned right here. And this is the interesting thing is, as I was learning this, most of your administrative judges, which are going to be your judges in the district and the circuit court, they only know that they only know statute and stuff. But when we send this off to the Supreme Court of Arkansas, these guys, those judges actually know the common law, and they know that anytime you invoke a common law court, no statutes. It's a superior court, and no statutes can be introduced at all. In fact, it's golly, here it is.
Now, that doesn't mean we won't have case law in the law of the case. There is case law to actually back up the common law. There's plenty, and that's what the law of the case is.
Here it is right here. So the law of this case. So anytime, so I guess it's just teaching them. Your question was, how are we going to make them see this? Well, it's all right here in the law of the case. This is actually on the very first page of Cheryl's case. It may be page 2. Yeah, it's page 2. Page 2 of Cheryl's actual case. It's called the law of the case. Actually, I have that document done. It's a 67-page or 63-page document. I will send it to everybody. When this is over, I will send everybody the law of the case that's in the Jural Assembly, because we're going to need this. But this one is done for Cheryl's case, okay? And it's highlighted with the laws. But it says anytime a court of records, and this is known, it applies to all causes of actions and all declarations at law in this court of record. So this is this court. So this court of record at all times, at no point or time shall these actions in this court of record be subject to the following for any reason: principles of equity, maritime admiralty, ecclesiastical, military jurisdiction, practice rules, appeals or decisions, save what the lawful tribunal. Remember, I told you guys, the jury is the tribunal, okay? Except what the lawful tribunal of this court of record shall deem appropriate. So guess what? Our jury deems appropriate common law, and when you deem the law of the land, none of those other sea time or air time jurisdictions can actually move in. And so once that's stated as the law of the case in the front, for instance, the Supreme Court that we're sending this to, John Kemp, he will absolutely know on the second page, okay, they're going to the common law. No statutes, none of that can be put in this case. So, I mean, it's laid out at the beginning of the case. And this is how they do things, this is actually how they do it in their realm. We're just putting our doctrine in their structure. The law of the case is actually their structure that they understand.
And I remind that the law that you're presenting is the higher law. That is the real law.
The period.
They need to be reminded when they interject themselves and try to slip it in and get something to confuse the air, that the ruling law is the common law, and their law that they operate under today every day is not going to be heard.
Correct. Right. So let me give it to you this, David. You bring up a good point. Let me bring it to you this way. So, for instance, let's just say that those defendants show up on Sunday, okay? Let's just say they show up. Let's say they show up. Cheryl has mentioned her case, that it is all common law. It's all mentioned in the correct jurisdiction. And all of a sudden, one of the defendants says, well, Section 8 of the USC Code of Title 32, blah, 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 says this, immediately she would say, I object. She would immediately say, I object. And what I've learned is that, and when she says I object, she says, I object. There's no statutes in this court. That's strike from the record. Strike it from the record.
Based on facts and evidence.
Based on, right, facts and evidence. So you would strike it. Now, this also works if you're in their court system, and you have made their court a court of record by doing this same paperwork, and you've done and made their court a court of record, you would always object. Anytime they try to pull you into their jurisdiction or they try to pull you in, you always object. What I learned from Bill Thornton and these guys is if you don't object, you agree.
Mm-hmm.
So anytime they say something, if you're in their court or in their realm and they say something, you have to object. Even if they just say duly noted, even if they just say noted or they overrule you, you always object. So if it happened in our case and the defendants actually show up, Cheryl would absolutely just have to be on the listen and just be listening. And if she would say, I object. Now, something else that can be done is a judge can object it, because our judges, our justices also know that we only go on law. If our justice caught that one of the defendants was using code or something to plead his case, then he could say, he could tell the jury, strike that. It's not part of, it's not part of law. It's part of the U.S. code, statutory, or it's not right for jurisdiction. Could just say any of those things.
Yeah, and you can count on them doing that.
Yes, if we have a defendant, you can count on them doing that. We would have to prepare whoever our claimant was to be ready to do just that.
Yeah. Good.
Now, on another note, this is something else. So we know that our court is the superior court of the land. It's more superior than even the Supreme Court, because that's going into their jurisdiction. Now, they're supposed to know that. When our case is decided by our 12-man jury of peers, which is owed to us in the Constitution of Arkansas and the other constitutions that we have in place, they should know that once this is sent with the verdict to that judge, he has to pass it down, because they actually can't overrule a superior court. 12-man petit jury cannot be overruled or retried in the common law.
Final.
It's final. Yeah, it's
Okay.
final, and it trumps every jurisdiction because it's general jurisdiction, common law land.
Mm-hmm.
So, but here's the thing, guys. We're the test case. Arkansas is the test case. No one else in the country has gotten as far as we have, and we're moving. So, this case will be making history. We'll see what happens. I mean, we don't know what they're going to do when we send it. So we're just going to keep moving forward. That's what we're going to do.
Amazing.
This will become one of the landmark cases.
Well, it's kind of like when we were talking to Terry yesterday with her case. She was like, Anna, why didn't this work? So there are steps, and this is going to go directly, this result is going to go directly to the Chief Justice of the Arkansas Supreme Court, and that's the final leg of it. So this, the grand jury, you sent it to the U.S. attorney and didn't get anything. So did Terry. So I think what she learned was that you do the grand jury, and then you go ahead and do your jury trial, and then you send it in the future. So all of, like you're saying here, this is great, y'all. But what we're doing is we're learning as we go.
Mm-hmm.
So there is no one ahead of us. So as far as learning from someone, there's no one ahead of us to learn. We're doing this. We're just doing it by the grace of Creator.
Right. Unless Arizona has gotten ahead of it and nobody knows it. We're going to try to find out, but we don't know. But yeah, from what we understand, we're the first ones.
So we are clearing a path for other people.
If we can do it, we can do it. Y'all have studied to the nth degree, and all we can do is what we've learned from what happened in the past, because there isn't anyone now to tell us. We have to take it from the past.
Turning over new dirt.
Mm-hmm.
This is Daryl. I was just wondering, do we have a commitment on 12 jurors for Sunday, or are we still We needs more time for people.
Well, I have a text message out to all of the Jural Assembly, and I've had a few answers, but there's some of you who have answered who I can't put you on the jury because you're officials. So I'm desperate for jurors. At this moment, I have 2. We've got to have 14, and we have to have 14 in order for this to work.
This is
so
Jimmy.
Yeah.
Can I ask a question?
If y'all can get there, that'd be great. Go ahead, Jimmy.
So you're talking about the text you sent today?
Yes, I sent a text out today asking about jury.
It says Sunday, September 21st.
Right. Oh, it's not supposed to be Sunday, September 21st. It was supposed to be January 21st. I don't know how I put in September. Don't even ask me how I did that.
That's why I didn't respond. It was so far out.
Okay, well, I'm sending it out again to everybody. I got to have 14 people reply. If you are an officer, you do not count as a jury member. All right, I will send it out again. But and once I have the 14 confirmed, then those 14 will be getting information, like the court's information, yes.